Welcome to another episode of the Effective Lawyer Podcast. I'm Jack Zinda, and I'm here today with Max Massey. How are you doing, Max?
I'm doing great. Happy Friday.
Happy Friday, man. Bar results come out next week. A lot of nervous people.
A lot of nervous people. Shout out to our two law clerks. And I was reminiscing with them today.
It was a long time ago for you, right?
It was a long time. It feels like just yesterday because I remember the morning of last year, the bar results website crashed.
Wow.
And
That's
so
amazing.
Results didn't come out. I was running late because I was just frantically checking.
Yeah.
And Paige, fiance, soon to be wedding. I don't know how.
Hopefully.
Yeah, hopefully, yeah.
We'll check this next year.
Exactly. She was like, well, what are you going to do if you don't pass? And I'm like, well, then it might just be a really short day at work. And so I get in and everyone's frantically like, hey, did you pass? Did you pass? Like, I haven't checked yet.
Yeah.
Like, why would you even show up if you didn't check? But obviously it all worked out, and I'm sure Samir and Julia did wonderfully.
It is so bizarre to me how Texas handles it. I don't know if they still do this, but when I was getting the results, they posted your name online. And if you didn't get it, like your name just wasn't there.
Yeah, that's still the same way.
It's such a weird way to do that. It's not confidential. It's just like, hey, we're just not going to share your name so all of your friends can see that you are not there.
That's it. And it's, we obviously every school has a couple people that don't make it.
Yeah.
And it's not the people that you see, it's the ones that you don't, that you immediately like, oh no. Inevitably, like, we'll post something on social media, like kind of walking that thin line of so proud of all my classmates, like on to February or something like that.
We unfortunately we've had a couple law clerks that didn't pass and it was really rough. I felt so bad for them when that happened, because it's tough. Like, it takes another 6 months before you can take the test again.
It's so frustrating, but here we are, and helping out a lot of families, knock on wood.
Yeah, man. And well, this podcast is for people that have passed the bar, about to pass the bar.
Yeah.
And today we're going to talk about wrongful death cases. We've got some questions that we've gotten around from the law firm, but also from other attorneys I talked to, and some of the pitfalls and tips and tactics you can run for wrongful death cases. And I thought it'd be great to have Max here ask me some questions, since he is relatively new, about 18 months as a lawyer.
Yeah.
So Max, what questions do you have on wrongful death cases?
So it's actually incredibly pertinent because I'm working with one of the partners, Neil Solomon, on one of his wrongful death cases. And just being able to navigate with him is really insightful, really interesting. Obviously, Neil's the pro's pro, so he knows exactly what he's doing.
Yeah.
But for people who don't know, for people in smaller firms who have never had a case like this, what are some of the pitfalls? What are some of the mistakes that they might do early on?
I think the first thing is figure out who your client is. And every state is a little different. There's typically two types of cases in a wrongful death case. The first is going to be the beneficiaries, which is typically going to be the children or the parents and the spouse. Now, this is state dependent. And why I say this is important, because this brings up a lot of things like conflict of interest, also how the money's going to be divided, and how you're going to pursue and approach the case. So let's say I have a client who their husband was killed. They have 3 children, but he was also married before, and they had a child from that marriage, or he did. And then he has parents, one who is alive, one who's deceased. And so how do you figure out who is bringing the claim and what they're entitled to? So I always first draw a family tree. I find visuals are really helpful for me, especially in these, because if you do it once, you kind of have it saved and you can always reflect back to it. And then I'll put their name, I'll put their role, and I'll usually have a nickname for them. I'll say, this is mom. She's a teacher, 58. This is estranged girlfriend. They have a 2-year-old. And then the other person that can bring a claim or entity is going to be the estate. And that's as if the person had survived and was like their pain and suffering, and also the loss of inheritance and those things, the economic damages from the person that died. So some states are a little different, but typically either can bring one on behalf of the estate or behalf on the claimant and beneficiaries. And another question I get a lot of times is, how much is each person entitled to? And that's going to be very case specific. And it's actually one of the hardest things to do if you have a case with multiple clients, because you have to be really careful on, representing each equally if you're representing a bunch. And you can run into big troubles, both from a malpractice and bar complaint issue, if you have people that can't get along, and also there's a conflict that you can't overcome.
Now, have you ever had a situation where you represented one of the beneficiaries and another attorney represented another one?
Yeah, that happens all the time. And sometimes I've been contacted by someone who, let's say it was they lost their son and they'd been divorced from the other parent, and they initially brought up, well, maybe you represent my ex-husband as well. And then I found out they hate each other's guts. They don't get along at all. And my advice in that situation is to refer them to someone that you can work well with if they're looking for a lawyer, opposed to you taking the risk of trying to represent two people that hate each other, because it can run into serious issues when you're trying to decide how to divide the sums. If you're going to do that anyways, make sure you get an agreement between the parties on how they're going to settle the case at the end. These are called aggregate settlement agreements. And a big tip in this situation is you want to do that before real money's on the table. It's much easier to get people to agree on a percentage than actual dollars. So if I have a wrongful death case and I represent two people, if I can get them to agree on a 50-50 split at the beginning of the case, that's going to be much easier than if there's $1 million on the table and now it's real money, and they're much harder to get along with in that situation.
That makes sense. And speaking of real money, I'm not saying it's easy to value, injuries or anything like that, but at least we, when there is a car crash, a premises case, we have the medical records. How do you value a wrongful death case?
Yeah, that is a great question. And it is challenging, but it's definitely doable. You have to start with the baseline of what would a jury give in the same or similar case? And what is the range of outcomes that could happen here? And in a death case, you're really starting with what's the story of the client? Who were their friends, their family? What was their life like? The second component you're going to look at is what did they go through when the incident happened? We had a case where someone was killed and they were drugged for about 15 feet under a truck, and they survived for about 15-20 minutes at the scene. And this is kind of gross, but the defense was arguing they had no conscious pain and suffering because they were knocked out and they didn't feel anything. We hired an expert that proved that she did have conscious pain and suffering because the way she was breathing, the eye contact she was making. We used a medical examiner to help us with that, because that 15 minutes of knowing that you're not going to make it to the other side, knowing you're never going to see your kids again, choking on your own blood, that's really gross stuff. And it's horrific what she went through. And that's an important level of damage to show the jury. And if you don't get that in, that doesn't come in the case, right? You don't just automatically get that damage. And that can add a lot of money to what your clients can ultimately get. But back to the original question, how do you fight? First, I would look at other verdicts. The second, I would look at how many claimants you have and how good is the claim that that individual person has. If I have someone who is a 10-year-old child and they lost their father, that case is probably going to be worth more than if it was an adult, let's say a 45-year-old child who lost their 75-year-old parent. Now, that's not always the case, and these are all generalities, and every jurisdiction is different on how much you can get in an individual case. But I always start like, what's the story with them and the person? If you have a case, for example, where there was a deadbeat dad who died, and the child is coming to you, and they haven't seen them in a long time, that damage model can be a little more challenging. Now, what we've done in those situations is we have told the story of missed opportunities to rekindle the relationship.
Okay.
To, there was an opportunity before this terrible thing happened for them to come, which happens a lot with adults, later on in life. And that was taken away from them. We had a case where this adult, he was probably in his early 50s. He died on a construction site. And it was really interesting. This was before body cams were really a big deal, or most people knew they existed. And actually, the police officer on the scene had gone there, and the worker had pointed up to where he fell. It's like he fell right there and he landed there, and he wasn't wearing this stuff. And it was actually really good for liability in that case. But the hard thing on that one was he had not been the best father, and his daughter was like 24 years old, and they just started hanging out with each other again like a year before this happened. And the defense was making a big deal about this. He wasn't a great dad, and there was an acrimonious divorce. But
So the defense will actually say this is a tarnished relationship. This was not a good person.
yeah, and if they're a good defense lawyer, they don't say it that aggressively.
Okay.
If they're a bad one, you can kind of lure them into that, but they imply that.
Yeah.
They'll tell you that in mediation. They'll tell you that in those other situations, but then they'll be more smooth about it at trial. And what they're trying to do is contrast the relationship to what people consider a high quality or a strong relationship, versus someone who doesn't have a strong relationship. But in that instance, we did this really interesting technique called psychodrama with a really great person, Pat Montez, who we've worked with tons of times to help prep witnesses. And she's amazing, so gifted. Where you go through what the people went through in their memories with the loved one. And we actually had the ex-wife come in and the daughter, and we went through when they were at the hospital and they had to pull the plug. We went through some of the memories when she was a kid, brought those to life, because a wrongful death case is about telling stories about what was and what could have been. And you have to paint a vivid picture for the jury of what that is. And you want them to compare it to their own life or people they know there's lives to show, like, what is this missing hole? Every dinner, the person's not there. If they call them every night, they're not going to be there to answer the phone. They're not going to be there for the first wedding. They're not going to be there for, the grandkids being born. And those stories are really powerful in deciding what the case is worth. And then you want to focus group it with the evidence. And you want to make sure you include the bad stuff on your side as well, because the defense will be smart about how they get things in. And trust me, if they were abusive at all, that's probably going to be coming in. If they, cheated on their spouse and you're claiming loss of consortium, that's an issue. That's a fact question now because you're bringing that into play. So you want to really think about what the damages you're bringing up. We've had situations where we intentionally did not present the wife's wrongful death claim because it was really, they had a bad relationship, but the kids, it was great. And it was going to detract from the overall case, the impact of what was going to happen. And so once I have all that information, I've got the jury verdicts from other cases, I've got focus group information, and then I use my own experience to decide what it's worth. And make sure you always do a charge. There's a big difference between a case with 15 lines on the charge and one with like 3,
Going back to the focus groups, I've been a part of 3 now, and it's always interesting trying to find that happy medium of we want to advocate for our client, but we also need to present all of the bad facts.
Yeah.
How do you present that in a way that it almost doesn't seem like you're advocating for the defense? And I say that half-heartedly jokingly because the last one we did, the focus group organizer messaged me back and said, "Hey, it almost seems like you're giving the defense more than you're giving yourself."
Yeah. Well, I think that's important to do in focus groups. And we do almost all virtually now. But when we were doing a lot in office in person, I would tell them, it's a little fib, but I don't think it was that bad. I would tell them that I was hired by both sides, that I was a trial lawyer and I used to travel a ton for my job. And I decided to start doing focus groups so I could spend more time with my family. And so, because I've handled a lot of cases, the plaintiffs and defense trust me, and they brought me this case here today to present to you. And my job is to tell both sides of the story of this case. So that's one trick to try to make sure, because even if they know you're on the plaintiff side, they will have bias towards you because they don't want to let you down. And then I try to think of what are the worst facts for me that are going to come in, and I make sure to include those and any that are borderline. And on our own facts, I try to make sure I say it very objectively without any sort of spin on whatever I'm trying to say. And I think also videos, pictures are really helpful as well. A lot of people make the defense's case way worse than it might be at trial, and you get kind of not great results because it's not helping you. And I would say focus groups, the hardest is on valuation. There's some really great focus groups that'll do with really big data sets now. I'm blanking on the name. I'll put it in the show notes, but there's 2 or 3 that do a great job with that we've used. And they'll get big data sets of focus groups, like 300, and give you some rough values based on 300 people. And once you get to that number, you can start getting kind of accurate of what a jury might actually give based on the evidence you have.
So one that I guess we'll give them the free shout out. Also, shout out to the iPhone storage being full.
I know. I believe this one is recorded. Crossed.
Fingers crossed. If not, we'll just hang out again.
Yeah.
The one that we've used recently is Emotion Track.
Yeah, and that's what it was. Yep.
Yeah, and they gave us so much data. And the one that we used prior, and I'm not going to besmirch any names here. The things that they would bring us, and we just settled that case, but the biggest critical fact that they were able to surmise from the actual focus group was that we need jurors who watch the show Blue Bloods.
Really interesting. That's crazy.
I was like, of all of the hours of this focus group, that was the biggest takeaway.
I mean, was there like 12 people that watched that show?
I guess. It was like...
I mean, I don't even heard of that show.
Yeah.
It's got to be on CBS.
Noted about 3 times in
Wow.
there. And I was like, of all things. But, going back to this, how do you... Obviously, wrongful deaths can be incredibly emotional, especially when you put real money out there.
Yeah.
How do you navigate, the intense family relationships through all this?
You have to have a lot of emotional intelligence. First, know how to read a room, and you need to decide if these people should be together or not when you're handling the case. I, a lot of times, will not have the folks together if we're mediating, because if there's tension at all, have them separately. The other thing is I try to get them to work through the emotions as early as possible in the case, as far as their problems with each other. If it's siblings with the parent, and then you really want to make sure if you're representing multiple people that you had that aggregate settlement agreement, and you talk about that it's difficult if the relationships are close to parse like what's more or less it worth. I also have a general rule: if I'm representing a child, like a small child in a death case, and I'm also representing the grandparents of the person that's deceased, I won't represent the grandparents unless they are upfront going to give a big majority to the small child. And I've had situations where it surprised me where they wanted an equal share. I'm like, this is a 5-year-old. Your relationship was important, but this child is not going to have a dad forever. And so use common sense, always bring the temperature down, be very careful in the conflict rules, because remember, you have to share any evidence given to each other. You can't hold back if representing both people. And a lot of times it's a lot of talking, a lot of sitting there and listening, letting people be angry, be mad, and you have to be okay with just kind of absorbing that and then helping them get through it. I also, in death cases, especially involving children, I try not to give as many updates to the client as I do in other cases, because it's just a reminder. It's just like a painful point. Sometimes they want a lot of updates, but I actually find a lot of times they don't want as many as in other cases. And maybe I'll call like a friend of theirs they'll be a next friend in the case, because those are just so emotionally charged and so difficult.
That makes sense. There's emotions, but there's also a lot of evidence in these
Yeah.
cases. So, what from the jump is important to do to make sure it doesn't come back to bite you?
First, what I said before, do the family tree. And I see people miss this all the time. Get birth certificates, death certificates, marriage certificates, divorce decrees. There's so many times when people think they're divorced, they're not.
Yeah.
They don't think they're married, they are. Oh man, we had this crazy case when I first started practicing, and we got hired by this grandmother who had a 5-year-old child, and it was a relatively young grandmother. The son had a child at like 22 or something. And he lived with his mom, never married. And the child's mother hired another lawyer, but she didn't have a claim because they're not married.
Right.
Well, she was claiming that they were common law married.
I was about to bring that up.
Yeah. And in Texas, to be common law married, which almost nobody knows this, and it's kind of crazy, you only have to have 3 things. One, you have to cohabitate, you have to agree to be husband and wife, and you have to represent to others in writing that you're married. So if you file joint taxes, if you tell people that you're married, that can be married just as powerful as like you went to the courthouse.
Yeah.
And so she was claiming that he called her his old lady, and that meant that they were married. Now, this brings up such a difficult issue, right? You don't want to be fighting about that in front of the jury. Think about what that does to the value of your case. Like, now everyone looks greedy. They look terrible. Like, grandma's arguing with, maybe mom of the child. And so that was a really, really difficult situation to navigate. We were able to handle it and get it kicked out in a family law court. That way it couldn't come in the personal injury case. For some reason, they never told the defense about their claim. I was able to convince her lawyer just to go through me and not bring it up because it would hurt the case. And they
Right.
agreed to do that, which helped a lot. The other thing is, we've had situations where the defense tried to get a DNA test to verify that a child was the person's. I would not agree to that if someone's already been adjudicated as the parent,
Right.
because under most states' laws, that even if it did come back as a different genetic, that they're still the father or mother. Well, mother we would know, but father under all legal circumstances.
Right.
It's a weird wrinkle. But get the birth, death, divorce. I always get the divorce certificates in any big case I have, even if it's not a death case, because there's so much stuff in there. They may claim abuse. They may claim, because people get really angry during divorces, and the other side will find that stuff.
Right.
The other thing is get the ME's report, medical examiner's report, that'll have the cause of death. You may sometimes hire your own ME to do your own examination. That's rare because you have to really be on top of the case fast. I've only done that one time, but most of the time the ME will say like, what was the cause of death, and have some indications about what happened, especially if it's a wrongful death and someone died from unnatural causes. Some other things to do: go to their house to get evidence of what their life was like. Pictures, videos, talk to friends. That can be very powerful for those cases. Even if you go to the funeral, or if they had the funeral, ask for the videos that they put up. They usually play videos at funerals, like memories of the person. Get those. Those are great to show what the person was like, what they went through, those sorts of things.
What about, critical evidence to the case? If it is a wrongful death via a crash or anything of that nature.
Well, one, figuring out what the mechanism of the death was,
Mhm.
that can be really important. And then 2, so I had a case where it was a fire death case, and it came down to how the fire started and how they died. And so we went out to the scene to see actually where his body had been, and the pictures were gruesome because there was pictures of him like reaching for the doorknob in his like charred body.
Wow.
But knowing like where the setup was, like where the fire would have started, I like to know everything surrounding the incident itself and try to see if I can recreate it in my own head. Like, where did it start? What occurred? What happened next? We've done it in a lot of industrial accident cases. And that, again, the mechanism of injury is really important because if it's a gas explosion, what was it? The gas blowing up against the wall? Was it a burn? That also can affect your damages because what did they go through prior to dying? We've done accidental shooting cases and you watch the movies and it looks like gunshots don't really hurt. You can shot and kind of like you just die, but actually they're very painful. If a bullet goes into your chest, it goes into the lung, goes into the cavity, blood is coming in, you're actually choking to death. And that's how you die. And that's horrific. So that evidence of what happened can be really important as well. And if it's a truck or a car wreck, the seatbelt usage, the airbag, don't fall for this trick. The defense a lot of times will not bring this stuff up and they'll say, it's like, give me a liability case. We'll agree, liability is clear. But then you get to trial and they'll say, well, maybe 90-10, maybe 80-20, maybe 60-40 is whatever the jury wants to do is fair. And they'll bring up stuff that you didn't think about because you thought it was a guaranteed liability case instead of plugging those holes. So don't fall for that.
Okay. In terms of the defense stipulating to liability, do you just agree to that, or is that something you would fight?
Well, you can't necessarily fight a stipulation of liability if they want to agree to it. But what you can do is get in the evidence you want to get in through other mechanisms. One, punitive damages. If that's an issue in the case, you can bring in there. Also, you can bring it in through the non-economics of the case itself. So if it's a drunk driver and they hit and hurt or killed someone, the fear of being on the road, given there might be other drunk drivers out there, can be part of the mental anguish damage. Also, telling the story of what happened is important to explain the damage model. But that's a common trick I see when it's a clear liability case. Also, you want to make sure you brought in the right people. So if it's negligent training, negligent supervision, they typically will not concede to that, right? So those other claims can be helpful for getting the evidence that shows the full harm because you have to do that to get full justice for your client. Like if things don't happen in a vacuum, right? The jury needs to know what occurred to really fully adjudicate the case. Yeah.
Now, let's say everything went swimmingly. The defense says, here's all the money. We're good to go. Have you ever had or seen situations after settlement where you're like, oh no, this went wrong?
Oh man, so many times, not really went wrong, stuff we anticipated, but I knew was going to be a problem. So, one example is you cannot find one of the beneficiaries. That happens a lot. So, like, you've got everybody lined up, the defense wants a full and final release, and someone's missing, and no one knows where they are. Sometimes you can get the defense to carve out a portion for that person and just set it aside for them if they ever show up. Most of the time, they want you to indemnify that person for future claims. So, sometimes we'll just say no and keep pushing the case to get closer to trial and they'll cave sometimes. Sometimes we will figure out a way to craft the waiver that protects our clients but doesn't indemnify them against this person's future claim. Sometimes we'll let the statute of limitations run out if it's close on that. That way the claim is extinguished and you don't have to worry about it. That's probably the most common one. The other is you need to make sure how you navigate subrogation issues. If you're not representing the estate, you do not have to account for liens. In Texas, this is my own personal opinion. So check your own statutes. All this stuff, check your own statutes. But you don't have to handle the liens because you don't represent the person that the lien is attached to.
Right.
So, but if you do represent the estate, all of a sudden you do have to deal with it, and you may have screwed your client out of a lot of money because you can still release all of the claims through the wrongful death beneficiaries if they're actually the heirs to the estate, and it can extinguish everything without having to deal with the lien issues that you might have to otherwise.
I like the explicit. This is not legal advice.
Yeah, it's in lawyers, right? This is not legal advice to anyone. This is barely advice.
So, I mean, in terms of attorneys who are out there trying to help out families who are going through this, what is kind of the big three takeaways that they should learn to not mess up?
Yeah, well, to me, and I think this is Max's way of saying he's done here. He's like, I got to get back to work. You keep me here till like 8 every night. You make me like sit in this podcast room. So I would say the three big takeaways. I would say number one, know who you represent, get the right documentation. That is key. If you don't know who you represent, you're flying blind. Two, always do a jury charge. Again, these are little simple things, but like if you have 15 or 30 blanks and you send to the defense, like, hey, they have 30 blanks to fill in. If they just do 130 times, that's $3 million. If they do, a million, that's $30 million. And once people start filling in blanks, it's easy, right? And number three, think through the conflict issues and really I'm gonna add a fourth. With all the different folks you're representing, and don't be greedy. Gosh, it can really kill you, and you can get in trouble, get a bar complaint, get sued, and it's not worth it. There'll be another case. And I'd say the fourth is get the client's story. You really, to maximize value, you've got to tell the story, and don't give up if you at first you don't think they had the best life. Everyone has a story to tell. It's either about the past or it's about future, like lost opportunities. They would have turned their life. They were an alcoholic, but they wanted to turn their life around. They had hopes to turn their life around. They were a high school dropout, but they had a dream of being a craftsman. They were going to get there someday. And you have to tell that story through people and through pictures and through words to really make the most out of these cases.
There was a great quote that came out of TTLA last year. It was a lot of trial is just competitive storytelling.
Yeah, I agree. 100%. And who tells the best story wins. And you actually don't have to be the most, I know, charismatic. I mean, you can be relatively not charismatic and tell a beautiful, powerful story through pictures, through words, and let that do the talking for you and just get massive outcomes. Well, this has been great, man. I appreciate it.
Always a pleasure.
Always a pleasure, sir. And until next time, thanks.